and welcome to the weekly updates of the Bar Bulletin. Here are the legal latest development from the Supreme Court, High Courts and Tribunals of this week. The Supreme Court adjourned the appeal filed by Onati Fortune, remarking that even senior counsel appeared not fully aware of the Insolvency and Bankruptcy Code framework. The Supreme Court reiterated settled law. The court held that compassionate appointment is a concession and not a vested right, rejecting a claim for a higher post after the applicant and had already accepted appointment. In arbitration jurisprudence, the Supreme Court ruled that a sub-vendor is not a veritable party to an arbitration agreement and quashed the appointment of an arbitrator. Clarifying income tax law, the Supreme Court held that the Section 44C of the Income Tax Act does not distinguish between common and exclusive head office expenses incurred by a non-resident Indian counterpart. In a strong ruling on dowry debts, the Supreme Court set aside the Allahabad High Court's acquittal of a husband and mother-in-law, issuing directions for effective enforcement of the Dowry Prohibition Act 1961. The Supreme Court observed that Section 479 of BNSS has been introduced to declog prisons, while granting bail to the managing director of DFHL in a major bank fraud and fund siphoning case. Citing irretrievable breakdown, the Supreme Court dissolved a marriage after 24 years of separation. The Supreme Court questioned the Bombay High Court's blanket stay on investigation and granted liberty to seek reconsideration. The Supreme Court granted bail in the Mahadev betting app case involving alleged cash delivery to former Chhattisgarh Chief Minister Bhupesh Baghel. A reference to a larger bench was made on whether Section 148 NI Act deposit requirements apply to convicted directors. Strongly criticizing trial courts, the Supreme Court said that mechanical trials divorced from the search for truth lead to miscarriage of justice, setting aside a POCSO conviction. The court reaffirmed that waitlists do not create a right to appointment, upholding communal rotation by Cochin University. Notice was issued in a case alleging sexual assault on a woman lawyer inside a police station with directions for sealed cover preservation of CCTV footage. The Supreme Court clarified that creation of the security interest is the cornerstone of invoking SARFAESI, disapproving recovery actions prior to DRT proceedings. The court ruled that cross FIRs arising from the same incident must be tried together and reiterated that FIR alone cannot sustain conviction, acquitting a doctor convicted of rape. In succession law, the court held that leading questions in cross-examination do not lose probative value, upholding a will excluding one child. Check bounce complaints, the court said, cannot be quashed at the pre-trial stage on disputed facts, restoring Section 138 NI Act case. The Supreme Court emphasized sensitive judicial appreciation of testimony of minor trafficking victims and held that victim can assist criminal revision proceedings even after the informant's death. In matrimonial law, the court ruled that the financial dominance alone does not amount to cruelty, quashing a Section 498A FIR. Allahabad High Court rejected bail in an acid attack case. Allahabad High Court declined to quash ED proceedings in Grand Venice project case. NCLAT ruled that WhatsApp cannot display advertisement without explicit user consent. Haryana Maitri Sabha organized Haryana Cultural Heritage, which was graced by Chief Justice of India, Justice Surya, Delhi CM Rekha Gupta, former Haryana CM Manohar Khattar.